rise. The Court of Appeals now for the 6th District of the State of Florida is now in session. The Honorable Roger K. Gannon, Judge, presides. All persons having business before the Court of Law here give attention to the court. God save the United States of America, the State of Florida, and the Honorable Court.
All right, good morning and welcome to this session of the 6th District Court of Appeal. I'm Roger Ganem, presiding today. To my left is Judge Leslie Schultz-Ken, who we are pleased to have with us, sitting by designation from the 13th Judicial Circuit. And to my right is our Chief Judge, Daniel Traver. We will go ahead and get started with the first case, which is 23-4030, Phyllis Bursey v. American Traditions Insurance Company. Counsel for Appellant, please introduce yourself and let me know how much rebuttal time you'd like.
Thank you, Judge. May it please the court, my name is Chad Barr. If I could have 5 minutes for rebuttal, I'd appreciate that.
Thank you, Mr. Barr. Go ahead.
I think you picked the right case to start with this morning. We have a short briefs and a very narrow legal issue to get the day of oral argument going. We're here today asking the court to reverse the trial court's final order dismissing Ms. Bursey's breach of contract claim. As I mentioned, the issue in this case is very narrow. It's whether the trial court erred when it dismissed Ms. Bursey's lawsuit based on its conclusion that the lawsuit was premature, based solely on the language in the policy, and by disregarding the language found in 627.70, 70152.
Yeah, I'll start this off, and maybe it's just going to give your colleague a chance to think about it before it's his turn. But, you know, to me, it seems like a pretty straightforward statutory analysis, and it's cabined in my mind by the Florida Supreme Court case law that says that when we have a statutory amendment, that we look at policy language within the confines of that controlling precedent. So you've got a situation where the statute is amended before the policy is issued, and the statute pretty clearly seems to say that this suit could be filed when it was filed. Now, whether the suit has any merit might be a separate issue entirely, but it seems, if I'm looking at the plain language of the statute, that it allows your client to do what she did. Do you disagree with any of that?
I don't disagree with that. And I think it's important to understand, and it kind of segues into my first point, was the argument that the appellees are making here today is a merits-based argument. And what they made below was a procedure-based argument. And even under tipsy coachman, it doesn't work here because there's no record or evidence to support the argument that they're making for this, asking this court to affirm based on an entirely separate grounds. The argument that they made below and the fact that they're changing it now actually supports what the commentary that you just made about the statute's interplay with the policy. The argument below was that 627.70152 didn't apply at all. It didn't apply. They went so far as to even make the claim that they didn't ask for appraisal pursuant to the statute when that's controverted by the evidence in this case. The record demonstrates their second demand for appraisal said they were demanding appraisal pursuant to the statute. So the argument that they made below that the statute doesn't apply was the entire basis for the court's argument, or the court's conclusion, excuse me.
Well, it seems to me not just the court's conclusion, but the court's disposition, which is going to be a dismissal without prejudice, but requiring a new complaint to be filed.
Correct.
Which effectively jurisdictionally for us is
final. Right.
So if you've got and I noted the change in argument from below to here, and I do applaud the candor, frankly.
Yes.
But the effect of that would seem to me that if the argument that was made on appeal was made below, it would be a dismissal without prejudice for leave to amend. And the other thing that kind of struck me was the idea that by the time that dismissal order was entered, the 60 days had run in terms of the time to pay out under the policy. So I think I appreciate what you're saying on two levels. Number one, I appreciate it in the sense that it would be a different disposition, seemingly, And then secondly, it would be a distinction without a difference because you wouldn't have the factual predicate that was being made before us because
Right.
the 60 days would have run.
Right. And so there's a couple of other issues too. And I think, kind of an overarching one and one that wasn't addressed below because that wasn't the posture of the argument, but was whether or not the 90-day provision in the statute is a 90-day deadline to complete appraisal. What's interesting is I know this court has conflict with the Cole versus United or Universal Property and Casualty as it relates to retroactive application of statute. But the court, the fourth DCA said in that case that the insurance company has 90 days to complete appraisal. So there's an additional question of whether or not appraisal is waived by them not completing it. There's an issue of whether or not they breached the appraisal provision by requiring a release. They attempted to require a release in April. Ms. Bersey to sign a release in order to get the appraisal funds. There's all these circulating issues that weren't dealt with below, and they need to be dealt with. And summary judgment issues probably, but they need to raise the affirmative defense, and we need to file replies, and it needs to be litigated on the merits.
Mr. Barr, my question is, given that you were not given leave to amend, to give you relief here, do we need to decide that you have any claims left, or is it simply enough for us to say it was error to dismiss with no leave to amend and just leave it to you to amend if you've got something or not? In other words, do we need to say that you have claims left?
I don't think you do, because that wasn't what the trial court wasn't given the opportunity to decide that issue. I think we go back. They made some important statements below, which I think the court should key in on. At the hearing, in their response to our motion for rehearing, they said plaintiff would like us to be operating under the appraisal provision within 627-70152 because that would justify the filing of the lawsuit. We don't really need to go any farther. They were admitting below that if we were operating under 627-70152, the lawsuit was authorized, and now here on appeal they're saying the statute does apply. So,
aren't you just looking for a vacator of the dismissal?
Yes, and to proceed on the lawsuit that was filed.
Right, and you might have fee issues out there. I'd ask you too. There's a motion from your colleague as it relates to the lawsuit being frivolous. It seems to me that would be fair game as well.
Right.
Okay.
I agree. And that wasn't ruled on either. And as it relates to the fees, I found it a little humorous that they were making this white knight argument in their answer brief. We have to remember some things about this case. They offered to pay less than a third of what the arbitration actually awarded. They refused to pay the arbitration award for 8 months. The arbitration award was in January. They didn't pay it till September. They forced Ms. Bersey into appraisal. They didn't complete appraisal within 90 days. And they want to make this whole argument in their answer brief about attorney's fees. Well, 627-70152, this is not a 627.428 case where we just get fees no matter what. There's a steps that we have to take, and there's an award that has to be made in order for us to even be entitled to attorney's fees. So for them to be arguing that this is some nefarious act by our client to get attorney's fees, we were authorized to file a suit within 90 days, after 90 days, and that's what we did. We waited 105 days and then filed the lawsuit. It's up to them to raise the affirmative defense and for us to litigate the merits of the case. Judge Shreve, you keyed in on a lot of the arguments that I was going to make. I don't want to waste the court's time this morning. If there's no other questions, I'll have a seat. And
Good morning.
Good morning.
Court. My name is David Burr, and I represent American Traditions Insurance Company. I'd like to follow on to the question of the argument below as compared to the argument on appeal. It has always been American Traditions' position that filing this lawsuit during appraisal reflects that a cause of action didn't exist at the time the lawsuit was filed.
So wouldn't the cause of action had simply been failure to pay under the policy terms? I mean, we understand an appraisal was going on, but it wasn't completed. So as of that point in time, 90 days, past the beginning of the appraisal, we had an insured who still hadn't received payment under the insurance policy. So doesn't that at least provide a good faith basis for a breach of contract cause of action, understanding that maybe the remedy will come through appraisal, but they didn't have it yet?
I'll avoid the good faith question, but the answer would be no, they would not have a cause of action for breach because, Your Honor, what you're describing is a disagreement about the amount of loss. And under the policy,
It could be coverage though, couldn't it? Like if the argument is going to be my roof leaks and you're refusing to pay me for it, isn't that the basis of the claim? I mean, appraisal is a statutorily created feature. And certainly there's a different argument that y'all have here as opposed to below about what the effect of that statute is. But I think it's just this lady's roof is leaking and the insurance company isn't paying to fix it.
it's specifically, and the parties agree on this, specifically as appellant's trial counsel acknowledged in the hearing below, American Tradition's obligation was to pay an appraisal award. The problem is at the time the lawsuit was filed, there wasn't an appraisal award. So that obligation, that the parties agree, was the obligation, hadn't ripened, let alone had it been breached. And
Are you saying at this point, are you going back to what your client was arguing below? And I recognize that you weren't the lawyer who made that argument, but are you going back to what your client argued below, which is that the statute doesn't apply because the policy controls?
No.
Okay. So if you're on the appellate argument that under the policy's language, the time to pay out the award hadn't happened yet, how is that justification for a dismissal of the lawsuit and a directive that it would need to be refiled under another case number? Why wouldn't it just be a dismissal to leave with leave for to amend, when that 60 days to pay under the policy had run, which by the way, it had by the time the trial court issued the order?
Correct, it had. The reason comes back to the fact that there wasn't a cause of action at the time the lawsuit was filed. And so that goes back to Voges. The Florida Supreme Court tells us the general rule, and I don't want to misquote it, I have here, is that the right of a plaintiff to recover must be measured by the facts as they exist when the suit was instituted. So the appraisal award was not a fact. The running of the 60 days was not a fact. So none of those give a basis to the lawsuit that was filed.
So you're getting to the lawsuit's merit, right?
Yes.
Which theoretically would have been the subject of the sanctions motion that was filed below.
Yes.
And it seems to me that your colleague properly just conceded that if y'all want to fight about what the lawsuit's merit was at the time of filing, you can do it if we reverse this and vacate the dismissal. I don't understand the magic of making them refile under a different case number when you're effectively, and I get you don't have an appellate burden, but you're effectively conceding that the statute controlled in this particular context, and they could file the lawsuit. The statute says, I can file the lawsuit. You're saying, well, you might be able to, but I disagree that it has merit. That seems to be a much more of a substantive type defense that you would just address via affirmative defense or sanctions motion.
So there's a couple of points to raise in response to that. The first is definitely these factual matters are often raised or ordinarily raised, either in a judgment on the pleadings or motion for summary judgment, but in any event after an answer, right? However, American Traditions filed a motion to dismiss, and on appeal, the question of whether that was the appropriate vehicle wasn't raised in the initial brief. So that's not a question that would be dispositive on appeal because that wasn't submitted for this court's review.
Help me understand that, because the way that I read the initial brief was the trial court erred when it dismissed the lawsuit without prejudice, but having to file a different lawsuit because the case was prematurely filed under the policies language. In other words, yeah, I mean, so how is there a appellate presentment issue when that's the declaration as to why the trial court erred? And it seems to me, I don't want to put words in your mouth, but it seems to me that you're conceding that on those grounds, they're correct. What you're saying, I think, is we should affirm anyway because the lawsuit has no substantive merit.
I'm saying two things. They are challenging not the vehicle that are in the initial brief, but the decision. And the decision is correct that if the lawsuit is using the word premature under the policy because the appraisal hadn't been completed, that shows that the trial court's decision was correct because the cause of action doesn't exist. And if I may draw the court's attention to a brief point in the record, during the hearing below, Judge Schreiber posed a question to Appellate's trial counsel. I'm assuming this insurance contract has the standard requirement that the appraisal is a precondition to filing of a lawsuit. Am I right on that? And the response was, "You are correct, Your Honor." So there's no dispute that that is a condition of filing the lawsuit. The court found that because the appraisal had not concluded, it was premature and dismissed it.
But the statute, which predates the issuance of the policy, says that you can sue after a set time period that everybody agrees it run.
But that does not mean that a cause of action had ripened. It simply means that you would not have the defense of this is premature under the statute.
How do we read that language, though, other than to say that you can sue? Like, it doesn't, if that view is correct, then how could anyone ever, how could a insured ever take advantage of that statutory amendment by filing a lawsuit when appraisal hadn't completed yet?
Anyways, the 90 days is a period in which the parties ostensibly are working together with the appraisers. And remember, this isn't limited to appraisal. That provision says appraisal or alternative dispute resolution. So say, for example, the appraisers can't agree on an umpire. Well, the policy says you can petition the court to choose that. If there's a question about the impartiality, whether the umpire is disinterested, whether there's competency concerns, those can be submitted to the trial court. If someone's not communicating, if there are scheduling concerns, there's any number of reasons to petition the court. But in all of those cases, what you're asking the court to do is to help facilitate the conclusion of appraisal. It is not creating a mechanism by which you nullify the appraisal process and send the claim to litigation. That's exactly the opposite of what the statute is trying to do. And if we think about it, why would this statute require pre-suit notice? In other words, say you can't file a lawsuit, not yet. You have to give the insurance company a chance to respond. And explicitly, one of the ways they can respond, if it's a covered claim, is they can request appraisal. And so the statute is promoting appraisal. It's also promoting the opportunity to re-inspect if it's a denied claim, settlement,
Isn't it
mediation.
potentially also promoting fast appraisal?
Not exactly, Your Honor, to be honest, because keep in mind, this appraisal took 6 months. Imagine if we had a 15-building apartment complex. The idea that the legislature was contemplating that appraisals will normally, let alone always, be completed in 90 days certainly is not supported by my experience, though I know that's not relevant. But it's just not consistent with the way appraisal goes. It's much more consistent with the rest of the language of the policy, that the purpose of the 90 days is to provide a vehicle so that claims don't get trapped in limbo in the appraisal process. Right.
And I understand your argument, but could theoretically the legislature have put in different appraisal timeframes based on the size of the project if it wanted to do so?
It could, but I would say they did not put in any time frame for appraisal. This is a time frame for when a lawsuit can be filed without immediately filed without additional notice. But it does not somehow, certainly doesn't say, but it also doesn't imply that we would like to therefore nullify appraisal, all of the 90 days of time and expense that you guys have poured into it, goodbye, go to litigation. It's not generating litigation, this statute, but that's what this interpretation would do, and that would yield an absurd result. You'd have not only the wasted time of appraisal, you would incentivize delay.
Counsel, why does filing a lawsuit necessarily conclude the appraisal? Why can't they proceed on parallel tracks?
Well, if one has a cause of action, then perhaps they could. But if what you are attempting to plead is breach of contract and an element of that cause of action hasn't occurred yet, then you don't have an existing cause of action. And the law is clear about that. Each element has to exist and have occurred. But if what you want is payment of an appraisal award, at a minimum, you have to have the appraisal award. We didn't. So they did not have that cause of action. If they had petitioned the court, let's say there was a disagreement, they said, American Traditions, your appraiser doesn't know what they're doing. Your appraiser somehow has a conflict. And there's a dispute over that. You can petition the court to resolve that, but you're facilitating, you're not taking it off of the appraisal track.
Counsel, as I read the statute, the notice requirement is it applies to the insured when the insured has a claim under the policy. So before the insured can sue on that claim, the insured must give notice. And then the insurance company has some options for responding. But if the response is, let's go to appraisal, then when you read it all the way through, it gets to the end and say the appraisal isn't completed in 90 days, then the insured can file suit without doing anything else. It seems like when you read these provisions together, as we must, it's always talking about the claim under the policy. In other words, the statutory language doesn't say you can file suit if it concerns the appraisal process or the disinterest, whatever. If it concerns some aspect of the appraisal specifically, the statute doesn't limit the suit that can be filed to that. In fact, I think when you read it all together, it's talking about the same suit that the insured wanted to file but had to provide notice before filing at the very beginning. Can't the legislature have said we only want the lawsuit to be something concerning the appraisal process itself, not the claim under the policy, if it wanted to say that?
I suppose it could have said that, but I don't think it needs to say that to mean that. Because it wouldn't mean that if you have no cause of action, no longer is that a basis to dismiss your lawsuit, because we've blessed it by the expiration of 90 days after appraisal. The expiration of 90 days does not give rise to a cause of action. To your point, Judge Ganim, if they do have a cause of action, then they can file suit after 90 days. But when appraisal is the fact pattern, and the policy says that the amount of loss payable is determined based on the amount of loss, and that the amount of loss is determined by appraisal, then it will be the case that when the lawsuit is filed, assuming appraisal has not been completed, that neither party knows what the amount owed is. And let's keep in mind, they also don't know whether anything's owed. It is entirely possible that appraisal comes back at a number that is equal to or less than the insurance company has already paid, in which case they would not owe anything additional. But they certainly would not have breached that obligation. Not when you look at the facts as they exist at the time the lawsuit is filed. At the time the lawsuit is filed, you have an ongoing appraisal and no appraisal award. There cannot have been a breach of the payment obligation that the parties agree is determined by the award, which does not exist at the time. And if I may add one more point. This question of leave to amend was not argued again also in the initial brief. And that's understandable, although they made that argument in the trial court. It's understandable that they would have abandoned it here because an amendment doesn't cure the non-existence of a cause of action.
Wouldn't that request have just been futile, though, based on the trial court's ruling? Trial court's basically just saying, look, I'm not saying that you can't pursue this claim. I'm just saying you can't pursue it under this case number. It's effectively a dismissal with prejudice. So how could, yeah.
So I appreciate that point. And what we are not saying, in fact, I would say the opposite, is that we would have some sort of res judicata argument if they had filed another lawsuit based on the facts that unfolded during this lawsuit, such as the expiration of the 60 days. We wouldn't have said, oh, that's res judicata, because that's entirely inconsistent. It's the opposite of what we're saying here today, which is that, no, you cannot bring that cause of action. And so here, by amendment, you cannot do that. So we also would not say in that second case, res judicata, you could have brought that in the original lawsuit, because that's not our position, and that will not be our position.
Because of something you said, a dismissal is for a failure to state the cause of action. It seems to me like amendment is precisely the way that you fix that problem. But even beyond that, by the time the complaint was dismissed here, there had been an appraisal award, and there had not been payment within the deadline imposed by the statute, by the contract. In other words, it was late no matter how we look at it. Why couldn't the insured at that point have amended the complaint to state that, well, my cause of action is failure to pay the award? I mean, amendments happen all the time, and claims change over the evolution of a lawsuit.
Yeah, I mean, absolutely. Litigants reserve the right to pick their battles and so forth. But the law in Florida is that if you have no cause of action, not that you don't state one, it doesn't exist. At the time you file your lawsuit, amending doesn't cure that. That's not an available remedy.
Did the trial court decide that amendment would be futile because there is no possible way to plead a cause of action here? Or did they just say that the trial court just conclude that one wasn't stated yet?
The trial court concluded that they had filed the lawsuit prematurely because appraisal had not been completed. That was what the trial court's order said, and I cross-checked it to the hearing transcript, and it's very similar. But that would mean that the cause of action doesn't exist. There would be nothing to meritoriously state, hence the 5715 motion.
Which you could still litigate on.
We could. And if that's meritorious, I don't think that should be advocated for by appellant. And we're certainly not on appeal advocating for that outcome. We would ask the court to affirm, finding that dismissal was proper because having no cause of action, which the record establishes, is a ground to dismiss a lawsuit. Whether leave to amend should have been granted is not before the court because it wasn't briefed initially.
Thank you, counsel. Any more
Thank you.
questions? Thank you.
Just real briefly, I want to make just 3 points in rebuttal. One, we have to rely on the plain language of the statute. The statute, as Judge Agam pointed out, the statute doesn't say what you can file a suit for. It just says when you can file a suit. And we complied with the statute. In terms of this, the bulk of the conversation from Appellee's counsel was about a cause of action. Cause of action is determined by looking at the pleadings, taking those pleadings as true as alleged. The trial court was required to do that and didn't. So we alleged a contract, we alleged a breach, and we alleged damages in our complaint. How those come about and what they look like down the road is the subject of substantive motions, not a procedural motion at the motion to dismiss stage. And lastly, their argument below was nothing more than Ms. Bursey didn't comply with her condition precedent to allow the appraisal to complete itself. They have to agree that that's wrong because 627-70152 applies. It sets a deadline for concluding appraisal. That didn't happen. That gave, admittedly, they admit below that gives rise to the lawsuit. So we would ask the court to reverse.
Counsel, help me understand, the argument has been made that the cause of action didn't exist yet because appraisal wasn't over. So is completion of appraisal, is it right to look at that as a condition precedent to the cause of action, or is it simply a forum selection for one part of the dispute? In other words, if it's coverage, that goes to court. If it's the amount of loss, that goes to appraisal. Is it accurate that the cause of action itself depends on completion of appraisal, or does the breach of contract action exist independently of the appraisal being completed?
Yeah, I think our position would be that the appraisal was either waived or not timely completed or some defect with respect to the appraisal. Their argument was that you have to let it play out in order for you to file, because their policy says you can't file a lawsuit until appraisal has been completed. The statute says you can file a lawsuit if appraisal hasn't been completed in 90 days. So arguably condition precedent, but we complied with it because we waited the 90 days.
If you filed the lawsuit after the 90 days, and the appraisal is not yet completed, does the insured still have a duty to participate in that appraisal through completion, or at some point, or at what point is the insured excused from having to do that anymore?
I think it comes down to what's happening in that appraisal. I think in this case, Ms. Bursey, there's no dispute that she complied with the conditions of appraisal. Where it turns is when they don't pay for 8 months, when 3 months after the appraisal, they try and force her to sign a release, which, by the way, would have waived her right to interest, would have waived her right to supplemental claims, to reopen claims, all those things which are not required of the policy. And then there's the issue of whether they properly paid all the interest, whether it relates to the date of the appraisal, whether it relates to the date of the claim was reported. None of those things were resolved. And so I think it depends on how the case takes shape as it progresses. But is it a condition precedent? That was our argument. My position is they could raise that as an affirmative defense, which would then give us the opportunity to file a reply to it. And again, it's a whole concept of avoiding cause of action by an affirmative defense, avoiding an affirmative defense by a reply. Those are all available avenues in this particular case. So if there's no other questions. Thank you. We would ask the court to reverse. Thank you. Happy holidays.
Likewise.
All right, the next case is 24-1772, Camelco, Inc. versus FCCI Insurance Company. Counsel for appellant, please introduce yourself and let me know how much time you'd like for rebuttal.
Good morning, Your Honors. Tim Taylor on behalf of Appellant Camelco Incorporated. I'd like 5 minutes for rebuttal.
Thank you, Mr. Taylor.
May it please the court? Good morning. Once again, my name is Tim Taylor. I represent the appellant, Camelco Incorporated. This is an appeal that arises from an underlying lawsuit filed by Orange County against my client, Camelco, for construction deficiencies on an exterior lighting project at the Orange County Convention Center. The facts of that underlying case are somewhat controlling to this appeal, so briefly I need to get into those facts. As alleged, Orange County was the owner of the project who hired my client, Camelco, as a licensed electrical contractor.
Mr. Taylor, I think we're pretty familiar with the facts of the case. I'd like to jump right to the work exclusion, if we could.
Sure.
You rely on posi window. I know you argued posi window in your briefing for the property damage side of things. But again, I want to focus on your work exclusion. You also rely on posi window for that. But first of all, isn't posi window a coverage case? I mean, they didn't take the your work exclusion head on in that case, did they?
Well, Your Honor, I believe they did, and here's why. Because under the insurance policy, it's an insuring agreement to cover property damage. Okay, so property damage is defined in the insurance policy as damage to tangible property. Obviously, then there are exclusions. Well, first off, if you have property damage, they have to pay. So if
No,
you
there's an exclusion.
Sure, and if we go to posi windows, Your Honor, and it's at 1248, and here's why I say they did address it. Because when they were discussing the CGL policies in posi as well as JSUB, they write, the CGL policies define, quote, property damage as, quote, physical injury to tangible property, including all resulting loss of use. In JSUB, we explain that the other courts have also, quote, recognized that there is a difference between a claim for the cost of repairing or removing defective work. That's to your work exclusion, which is not a claim for property damage. So that's where we're getting it. If you can't have property damage and your work exclusion, because property damage cannot be part of your work. So in this case, when you have, if something is defined as property damage under the insurance policy, it can't necessarily also be part of your work exclusion.
So why have the exclusion?
Well,
If coverage is the end all be all of it, then why have the exclusion? And on top of that, why have the separate E&O coverage portion of the policy? If that's the end all be all of it, then there's no need for the exclusion because it's effectively swallowed by the coverage.
well, the exclusion of your work is the insured contract for work. It's that scope of work. Property damage is outside of that. So therefore, if property damage isn't part of the insured scope of work, it can't be part of your work exclusion. And that's why the Florida Supreme Court makes that distinction in posi and says, look, if you're giving owner supplied materials that are not part of the insured construction contract, they are considered property damage and not part of the work being performed by the insured contractor. And therefore, that's why when they discuss this, they say recognizing there's a difference between a claim for the cost of repairing or removing defective work, which is not a claim for property damage, and a claim for the cost of repairing damage caused by the defective work, which is a claim for property damage. So they're discussing the interplay between the your work exclusion and what is considered property damage. And that's why when we get into the posi and they talk about if a claim is for the repair or replacement of, you all know, it was windows that were not initially defective but were damaged by the defective installation, then there's physical injury to tangible property, which is what we have in this case. We have lighting fixtures that the county bought from a company called Traxon for hundreds of thousands of dollars and contracted with my client, Camelco.
So I have questions for your colleague about the trial court's decision on coverage because it doesn't make any sense to me based on the posi windows case. However, if we look at the plain text of the your work exclusion, just answer me two straightforward questions. Are the lighting fixtures materials? And two, who furnished them?
Good questions. One, they're not materials under the your work exclusion because they weren't furnished as part of the insured contract. The contract is insured.
How do you get to that under the plain, if I were to ask a fifth grader, is I'm giving you this box that has this light fixture in it. And I want you to open the box and screw in that light bulb over there. Would you say that this light bulb is a part? I mean, doesn't the fifth grader say, of course it's a part?
I'm not necessarily understanding that distinction, but I want to go to of what you talked about, your work, and you said materials. Under your work, it's
Well, sure. Materials, parts, or equipment furnished in connection with such work.
key. The key word is furnished in connection with such work or operations. The work or operations has to be the insurers. And so in this case, the lighting fixtures were not furnished in connection with our work or operations. We didn't furnish them. They were the owner's separate material and tangible property that they hired us to install. And that we can look at the
owner furnished the light fixtures to Camelco to be installed and connected and to make them work, right?
That's right.
So they were furnished by someone in connection with Camelco's work.
Exactly. It's the same situation as policy, where the owner furnished the windows.
So why does it matter according to the policy language who furnished them? They were furnished.
Well, it's furnished in connection with such work or operations. The such work or operations is of the insured under the policy.
Yeah, but we've established that Camelco installed the lighting fixtures.
Right, but they didn't furnish them.
And I think we're in agreement about that. Why does that matter? Because does the policy language require the materials to be furnished by the insured, or does it only require that they be furnished in connection with the insured's work?
They have to be furnished by the insured because the insured is getting paid for them. See, when they fall under the contract of the contractor supplying the materials, that is part of the contractor's work, because the contractor's furnishing those materials. It's part of his contract sum that he's getting paid for by the owner. It's part of the umbrella of scope of work in his contract.
I'm sorry, if we look at just the plain language, as my colleagues are pointing out, so the paragraph 22, the definition of your work, materials, parts, or equipment furnished. If I just take a plain language read of this contractual language, there's no distinction in who's doing the furnishing. Shouldn't the policy have specified, and aren't you asking this court then to add a requirement in that the materials, parts, or equipment only be furnished by the insured, when the language of the policy doesn't say that? Aren't you asking this court to make that additional requirement?
Well, I have two responses to that. One is, as you've noted, it doesn't say who furnished it. Okay, so all ambiguities in the insurance policy are always by law in the state of Florida ruled in favor of coverage for the insured. Therefore, since, as you said, it doesn't say who, just based upon that argument, there would be afforded coverage. But secondly, this is the same exclusion post 1986 CGL policy that the Florida Supreme Court was analyzing in JSUB, was analyzing in POSI. This definition hasn't changed. And if you start putting tangible property that is not part of the insured's contract as exclusions, it's almost impossible to underwrite that policy. It's easy to underwrite the policy when you know what the contractor's scope of work is, what he's furnishing, what he's doing. But if there's going to be arguments later about adding, well, owner furnished these, these materials, or another third party furnished other materials, isn't that now excluded? Well, no, it's not part of the contracted for scope of work. It's not part of the work of the insured. And this was a labor-only contract for Camelco. It was a licensed electrician installing the owner's products that they purchased from an international lighting company called Traxon. So if we look at Octor, which is what the trial court relied on, that was presented by FCCI in this case, even the Octor court noted, it's a federal case. I don't believe it has any precedential value. It's sort of odd that you've got a split decision with a concurring Dubitante opinion that says, this needs to be certified to the Florida Supreme Court, but I'll concur Dubitante. But if you look at what Octor says, they make the distinction. Look, they're saying there would have been coverage for these owner-supplied materials, but in Octor, these were raw materials, in this case, building tiles, roofing tiles, part of the roofing system that was assembled on site to create a completed system. They called it raw materials. Okay? raw materials assembled on site, some of which were provided by the owner. And in Octor, the damages was the replacement of the entire roofing system. So it's raw materials in a system, some materials supplied by the owner, but the owner wants a whole new roof because it was impossible to replace just some of the tiles. Therefore, it was a system, and the system is part of your work. Here, we have specific specialized lighting enhancements that are made overseas by an international lighting company that are shipped to the project, paid for by the owner, and the owner hires an electrical contractor to just install them.
Who
And then the owner
furnished
claims.
these lights to your client?
What's that?
Who furnished these lights to your client?
The owner furnished these.
I mean, how isn't that the end of the inquiry as it relates to your work exception? They were furnished to your client.
Because owner furnished materials are considered property damage and not considered part of the work under POSI.
Right. Because, and you're relying on posi windows for that, which is a coverage case,
That's right.
which doesn't deal with exclusions.
Well, respectfully, I believe.
And
it does.
Octor doesn't deal with exclusions either, right? It's a coverage case.
Once again, they both go to whether it's property damage. If it's property damage, and as Posse said, look, we're looking at property damage versus what amounts to your work exclusion or damages caused by your work. And because, as in Posse, as it noted, owner-supplied materials are considered tangible property. I mean, that is the law of this state. And the reason why it's such a policy issue here, in public construction contracting, there is such a large amount of owner-supplied materials for the tax breaks that the owners get. So there's going to be, on every job, 10 to 20%, in this case, it was 100% of the materials, but materials furnished by public owners, so they don't have to pay, they get the tax break exemption, it lowers costs, and they're making sure, obviously the contractor has GL insurance because they want to make sure everything is insured, including their products. If we go beyond that, and all of a sudden we go outside of POSI and we start saying owner furnished materials are not covered property, is not tangible property. One, I believe we'd have to have an opinion and take that up to the Florida Supremes to resolve that issue. But two, it creates an insurance coverage nightmare on these construction projects because
So I think we perhaps just might be talking past each other. Every time you say coverage, we agree with you.
Can't we find that there is coverage due to property damage, but also find that the your work exclusion applies?
No, I don't. I don't believe so, because if owner supplied materials are considered tangible property under POSI, tangible property is not part of the your work exclusion. Property damage has a definition, and property damage means physical injury to tangible property, including all resulting loss of use of that property. If you have tangible property, which POSI Windows has defined as property damage to owner-supplied materials, it cannot be part of the your work exclusion because your work exclusion doesn't include tangible property. It includes only your work under your contract. So that's why I don't believe. I think we're having a fundamental disagreement about whether you can have a decision identifying owner-supplied materials as tangible property and then say, but nevertheless, it's excluded under your work exclusion because the two can't coexist under the insurance policy. You either have tangible property or you can have a lot of things, but your work would include work that is not considered tangible property.
Then shouldn't your work exclusion have said in terms of the furnishing that the materials, parts or equipment can only be furnished by the insured? Shouldn't it have made that distinction in your work definition?
Well, respectfully, I think when you talk to it, the section's called your work. So when we're looking at, quote, your work, it means being a possessive pronoun, means it's your materials, parts, or equipment furnished in connection with such work or operations.
That you do, except that it does recognize or it could be on your behalf. I'm looking at the definition paragraph.
Oh,
22 of your work.
Yeah, you're right. And what that means, that's subsection 1, which is work or operations performed by you or on your behalf. On your behalf means subcontractors. Right? And then subsection 2 talks about the materials, which is what we're here under. And materials, parts, or equipment furnished in connection of such work or operations is under the, quote, your work. That applies to what the insured is furnishing. And that's a very logical interpretation that follows Posey windows. If there's another interpretation, once again, the ambiguity would have to go in favor of coverage.
Counsel, you're into your rebuttal time.
I appreciate the heads up, Your Honor. I will save the remainder of my time for rebuttal. Thank you.
Good morning, Your Honors. May it please the Court, Alana Ullman on behalf of the Appellate FCCI Insurance Company. Thank you for your time this morning. I'll dive right into the issues and the inquiries posed by this Court. It seems that the focal point is the application of the your work exclusion. I have many fundamental disagreements with counsel's statements about the law and application of your work in conjunction with the existence of property damage. I believe the case law supports and the plain reading of the policy supports the conclusion that the two very much can and must coexist. You don't get to the your work exclusion unless there is property damage. And I think the case law makes that clear. In the Octor decision from the 11th Circuit, which does rely on Florida Supreme Court precedent, the court notes that, I'm sorry, in JSUB actually, so actually in JSUB, the court said that the subcontractor's exception to the general exclusion for contractors' defective work becomes important only if there is coverage under the initial insuring agreement. So the court acknowledged in JSUB that we don't even get to discussing your work unless there's coverage under the initial insuring agreement. So we're past the point if your honors are inclined to find that there was property damage because, to counsel's point, the lighting fixtures themselves were the property purchase owned by the county. Then the next inquiry is there an exclusion that applies? And the your work exclusion falls squarely within this. The terms are broad. The definition, the exclusion provides that property damage, so we have to assume that there's property damage already, property damage to your work arising out of it or in any part of it included in the product's completed operations hazard. And then the definition, I don't necessarily agree that 22A2 is the only term that's relevant here. I think equally 22A1 applies because the property damage is to or arising out of the general work and operations of Comelco here.
Will it have to be both, right? Because there's an and.
Yes, but I think both apply just as importantly here in this context.
But in order for the exclusion to apply, both would have to apply.
No, yes.
Well, it's not an or.
Well, no, because it's the your work as a definition.
Yeah.
Yes, I agree. And I also want to add that the court correctly acknowledged that the JSUB and the Posey window cases do not involve the your work exclusion. The courts maybe tangentially addressed the your work exclusion, but they were not relevant there because the insured in that case was general contractor that outsourced the work to subcontractors.
I mean, neither is Octor, which is how the Octor is a coverage case. I mean, it more specifically says we don't have to reach the your work exception. So it's interesting to me because the only, and I expected your colleague to mention it at some point, but the only authority that's offered as it relates to the applicability of the your work exception is this Pinkerton case, which is a Northern District of Georgia case from 2002. And that has a pretty interesting way of defining furnished. And it talks about furnished in the context of furnished meaning materials, work, or materials, parts, and equipment that are furnished by the contractor in connection of doing the work. So in this case, screwdrivers, hammers, ladders, stuff like that. Could you please address Pinkerton? I understand that you disagree with it.
Yes.
But there's no textual analysis of Pinkerton in the answer brief, nor was there any textual analysis made below of furnished or Pinkerton in front of the trial court.
Sure.
So it seems to me that if your colleague has a hat to hang, it's going to be on that definition of furnished in Pinkerton.
Yes, absolutely, Your Honor. Well, first and foremost, as you noted, Pinkerton was a U.S. District Court case from Georgia. I understand it construed Florida law.
You won the case on a split panel from the 11th Circuit. So.
Yeah, no, I acknowledge that. That court addressed the impaired property exclusion, not your work. And I think that's relevant here.
It did. It talked about your work specifically under L.
It looked to the definition of your work, but it did not involve the question of application of the exclusion L, your work. It involved impaired property, which references your work, and reference to the definition was required. I don't think that it involved the question of the specific exclusion involved here, damage to your work, which is property damage to your work arising out of it or in any part of it, and included in the product's completed operations hazard. I think that it's much broader than an impaired property exclusion, M. Here, I think broadly the court can reach the conclusion that if we assume there's property damage, that the property damage was to the insured's work, which is defined as work or operation performed by you and materials, parts, equipment furnished in connection. Again, to your point raised earlier to my colleague, that there's no modifier that distinguishes who furnished the work. I think the plain reading is that your work embraces and encompasses materials, parts, or equipment that are furnished in connection with your work. And readily, often we see in the industry that the supplies are brought in by other contractors or owners and from other sources. And these exclusions are intended to be business risk exclusions to preclude there being coverage for any time there's just faulty workmanship to the work itself. If there was work, for example, if the lighting fixtures fell off and hit the ground and hit somebody or broke something, that's not necessarily damage because of your work.
What of his argument that furnished is an ambiguous term, that work can mean that it would be equally likely that it could be lighting fixtures furnished by the owner versus hammers, ladders, or screwdrivers furnished by themselves?
I don't think it's an ambiguous term. I think there's a plain reading. I think the discussion in terms of ownership of property in this context, at least under Florida precedent, is limited to the question of, is there property damage? And I think we've overcome that based on the questions of this court, that this court's inclined to find that there is at least at a minimum property damage. But I think looking past that, I don't believe that there's ambiguity in the term furnished. I think it's a plain reading that equipment is provided.
Just
doesn't
on
modify
that
by
point,
whom.
though, quickly, counsel, as it relates to coverage, like how are we not bound by posi windows? I mean, regardless of what the policy says.
On the property damage front?
Yeah. How is there not coverage in this case?
We're looking past the exclusion, just in terms
Well,
of
you're not even
property
to the
damage front.
exclusion yet if there's no coverage, which is what the trial court decided.
Yes. So I think posi window can be distinguished in a couple of manners. I mean, I'm not negating the conclusion to posi window, and I don't think Ofter is necessarily contrary to posi. I think its conclusions were reached based on posi. But that case had some factual distinguishers in it. There was substantial damage to the windows themselves in that case. That was the focal point of that case. The entire framing of the windows, everything was wrong with the windows themselves. And the court said that they focus on, the ownership issue to say that, well, that could be other tangible property, and therefore there could be property damage. But it was because the focus was on damages that the claimant in that case was alleging damages because of the issues with the windows. And in this case, the issue is not damage to the lighting fixtures. That's a misnomer. The focus is on the issue.
I mean, do they work?
But they're non-functional. Them being non-functional is not the same as property damage. So if I have a perfectly good television set and I install it, but I plug it in wrong and I mess up the wires, I didn't install it correctly. Did I do a faulty installation of the TV? Maybe, but is there damage resulting from it? That's not the issue in this case. I mean, I think this is important. I had this thought driving here was, would the claim, would the county still have their claim and the same quantum of damages they could seek against Comelco here for the improper wiring and non-functioning of the lights, even if there was not a single allegation or issue in terms of damage to the lights, no water infiltration, no issue? Could they still make their claim? Would they have the still same quantum of damages because they're just inoperable, not that they're damaged? I think they would. I think the issue is that they didn't adhere to, or allegedly didn't adhere to, the terms of the contract, the bid agreement, that required wiring to be done in a certain way, use certain types of equipment or whatever it may be, and they didn't, and it's not operable. Not that there's necessarily damage. And what's being sought here in the way of damages in the underlying case is to remedy the defects of the installation, the faulty installation here. And that's exactly, I think, Your Honors noted that there is E&O coverage under this policy, and that was properly paid here by the carrier. And the insured paid premium for E&O coverage with the understanding that the policy has exclusions for liability arising out of their work and their faulty work when the damage is to that work. The purpose of a CGL policy is not intended to provide coverage for those types of losses. And that's why, there's bill of risk purchase here, there's a surety involved in the underlying case, and those are there for a reason.
Counsel, if we disagree with the trial court on coverage, but we agreed with the trial court on the your work exclusion, we would have to affirm. But I want to step away from that one for a moment and talk about the contractual liability exclusion.
Yes.
I don't find much in the case law that's really persuasive from a textual standpoint of explaining what does assumption of liability under a contract mean. Because when I look at the word assumption, when I look at it in Black's Law Dictionary, for example, it's pointing to taking on a liability that wasn't otherwise yours to take, by contract. It doesn't seem to me to communicate simply, well, it's work you're doing pursuant to a contract, therefore the contractual liability exclusion applies. Can you help me,
Yes.
Textually get to why that exclusion applies in this case where, the contract required them to install the light fixtures?
Yes. No, I don't disagree. There's not a lot of legal authority that addresses this head on. We did cite to the Key Custom case. I believe it's might be a federal court decision from the Middle District of Florida. But that case addresses, and acknowledges that you can have breach of contract claims that are covered under a CGL and those that are not. There are some that arise out of tort and some that arise out of contract. And I think you really need to look into what the damages are being alleged here. And in the Key Custom case, I think it was a faulty construction that resulted in a house fire case. But the court said that although the property damage was tangential to the claim, the only relief being sought was for a breach of the contract due to not adhering to a certain substantial completion or repair protocol, something along those lines. And I think that's akin to the situation we have here, because essentially what I understand Orange County is
Can I stop
alleging.
you for a second, just so I
Yes.
make sure I understand that factual pattern? So you had a fire that arose as a result of a contractor's defective remediation work?
Not necessarily as a result of, but it was a consequence of the construction. There was a fire, and there was the house burned down. But the relief being sought in that case was under a theory of breach of contract due to failure to adhere to certain terms. I believe it was a substantial completion issue related to that, or timeliness issue. It
Because
was
to me, the
negated by the fire.
remediation would make sense because that contractor would be taking on the risk of a previous contract to complete it. Where I struggle with the trial court's decision on this particular exclusion is that in the normal course of talking to each other in the business community, when I enter into a contract with you as a plumber to fix the pipes, you're not assuming my liability for the pipes, which strikes me as the way that the trial court looked at that particular exclusion. In other words, the idea is, the owner and Comelco had this contract that had these specifications, and the argument is that they failed to meet those specifications. That doesn't strike me how I understand assumption of liability. It's just a contract.
Yeah.
Now, if they were fixing somebody else's mistake under a contract, maybe you could get me there, but it's hard for me under the pattern.
I understand. And that wasn't the focal point of our arguments in the trial level. So I understand why the decision really doesn't flesh that out. But I believe the case law would support the conclusion that the damages being sought here by Orange County against Comelco are economic in nature, based on the contract and a liability assumed to perform in consistent with the specifications. And the allegation is that they didn't use this right device or this right equipment or whatever it may be. And not that resulted in damages, but that the property is not operable. The lighting fixtures are not operable because of that. And so for that reason, we preserved and argued that the contractual liability exclusion would be a third tier basis to preclude coverage here. But the crux of our position is that the year work exclusion applies. And that's why FCCI issued its E&O coverage that does not impose a duty to defend, but it does have a minimum limit, I believe, of a $10,000 limit, which was promptly issued several years ago. And I don't know if it's worth the argument on the whether or not there's property damage at all. It seems that the court hasn't been decided on that. Our position is just that we believe that the Octor case does shed light on the property damage inquiry that's most akin to our situation, because although there was not a subcontractor, there's a subcontractor situation in that case and not in ours. In Octor, there was owner-supplied equipment or owner-supplied materials for the roof, and the court was able to reach the conclusion that because the issue was really with the installation and the roof as a whole, not just the individual roof tiles that were supplied, that was not property damage. And we believe that this is a similar type of situation where the focal point, the issue here is not the lighting fixtures themselves. It's the lighting system, which was the entirety of the scope of Comelco's contract. And we believe that's the reason, and that supports the trial court's decision to find there was no property damage in the first instance. And, I'll just end with, we did raise an argument in the underlying court and in our briefs just to preserve the issue on building code violations not constituting an occurrence. And I don't know if that merits much time. Candidly, I don't believe that that's a very strong argument here. But I do would kindly ask that the court uphold the trial court's decision finding that there is no duty to defend or indemnify in this case.
Thank you, counsel.
Thank you.
Thank you, Your Honors. Just briefly, I'd like to just remind this court that Chandler versus Geico Indemnity Agreement, Florida Supreme Court case has held that ambiguous language is construed against a drafter.
Yeah. You talked about that. Let's talk about that, because I think that if we get into Pinkerton, we're talking about furnished. So let me ask it to you this way. Let's say you're a contractor, and we're talking about your tools. And if you pick up your hammer, would you say I furnished myself this hammer, or it's my hammer? Because if that's an ambiguous term, and Pinkerton is either right in how it defines it, or it's ambiguous, then I think you're right. I think you win under that particular circumstance. I will tell you personally that I'm struggling with the idea that a contractor can furnish itself with its own equipment. Typically, when we talk about somebody furnishing somebody to something to somebody, I'm giving it to you.
And let me answer that in the context of how Florida has defined the lien law and furnishing, because furnishing is a big thing on liens and also bond claims. So when a contractor furnishes labor, materials, services, or equipment, he can furnish all four: labor to do the work, materials, rebar, concrete, whatever. Equipment, he brings his heavy equipment in, generators, whatnot. He uses that equipment to improve the real property and it takes away, but he's furnished it. You have lien rights for the time that equipment is on the project, helping you to construct the project. And that's where you get to the furnishing. You can furnish your own equipment. It doesn't necessarily, equipment doesn't normally stay in the project. You're just using it to build. So, but you've got to furnish it yourself for you to have those rights. Okay. And I think when we get into Pinkerton, that's what they also said. It's what is the contractor furnishing? The court in Pinkerton is following Florida lien law. When you're talking about furnishing under the insurance contract, it's the same thing. They don't consider, the contractor doesn't furnish to a project materials given to him by the owner. The owner's furnishing those materials to the project. The contractor's installing those with his labor. He's furnishing his labor, but he's not furnishing those materials. And that's why when I started with the applicability of the law and the ambiguity always going in favor of the insured, and especially in that case, you see exclusions are even a higher, more strict standard than just the regular interpretation of coverage. Looking at Pinkerton, they're following Florida law and they're following Florida lien law, but they're not necessarily saying, because that's how lien law.
Out of curiosity, in your research, did you find a Northern District of Georgia case from 5 years after Pinkerton called Johnson Landscapes that disagreed with Pinkerton? Or I'm sorry, that didn't mention Pinkerton, but also addressed furnished?
Johnson, I'm not familiar with that case.
It's okay, I didn't find it either. somebody on this panel did.
Oh.
So, okay, I just wanted to ask.
But Johnson, I'd like to look that up. What was it? Johnson Landscape?
Johnson Landscapes, yeah. And basically, for what it's worth, they disregarded Pinkerton's analysis on what furnished meant, basically saying it doesn't make any sense that you would furnish something to yourself.
And was that case interpreting Florida law?
It was not interpreting Florida law, but it was interpreting the same provision in the CGL policy.
Sure, because you can go to chapter 713, which is the lien law statute, and that'll define what furnishing is. And so you could look at
How does the lien law's definition, and it's an interesting point that you raised, it's the first I've heard of it. How does the lien law's definition of what furnished meant give us any technical guidance as to what furnished means in the context of a CGL policy?
because it shows who's furnishing. You know, you have to actually be the party furnishing or those on your behalf if you're a general contractor furnishing. Therefore, as a general contractor can lien, he can lien for all of the work that is substituted as well, and everybody down the line who have purchased the materials that are incorporated for the project. The general contractor cannot lien for owner supplied materials because he's not furnished them either through himself or his subcontractors. So when you lien a property, it's got to be for labor, materials, or equipment that you have the lienor has furnished for the improvement. And obviously that, implies and expressly states that the liener's got to be responsible for those materials, labor, and services. So in that regard, I think it's instructive on when you get to your work, it's your work. It's what you're furnishing, what the lien law allows you to lien for. It's just another, how the Florida legislature has determined who furnishes. So I see that I'm out of time, Your Honor. Respectfully, we would request that you reverse the trial court's summary judgment against my client, declaring that there is no duty to defend, and find that there is a duty to defend, and consequently vacate the ruling approving or the summary judgment for the Appellate FCCI. Thank you.
Thank you. All right, we will continue with the third case, 24-1622 Citizens Property Insurance Corporation v. Melinda Looney and Robert Lynn. I'll give counsel a few moments to collect their things. All right, counsel for appellant, please introduce yourself and let me know how much time you want for rebuttal.
May it please the court, Drew Peeler, I'd like to reserve 6 minutes for rebuttal, please. Your Honor, Citizens is entitled to remittitor in this case because the jury's finding that the Loonies were entitled to $5,000 for repairs to their roof is not supported by the evidence. In this case, based on the evidence that was presented to the jury, they had two options if they found that there was, in fact, cover damage to the roof. First, the cover damage could not be restored or repaired without replacing the entire roof. This was the Loonies' primary position, in fact, only position. And second, that the cover damage could be restored with a smaller spot repair, which was identified by Citizens expert Mr. Lynn, rather than the full roof replacement.
Counsel, let me ask you this question. I think this dispute, at least to me, kind of turns on this verdict form and the fact that the jury wrote 4 repairs after the $5,000 figure. There was space on the form for them to put in the dollar amount. They did that, but they added this 4 repairs notation. If that 4 repairs notation was not there, they had simply just said $5,000, would this verdict be excessive or would it be inadequate?
Your Honor, it would still be excessive, and that's because the evidence showed that it would cost at least almost $9,700 for the actual cash value at the date of loss. That was the smallest number presented for replacing the entire roof. And there was no evidence presented at trial that the roof could be half replaced. So the mere award of $5,000 shows that the jury disagreed with the Loonies' position that the entire roof needed to be replaced.
But I also look at that number 5,000 and see that it's about $4,500 more than the highest repair cost that the evidence supported. and it's about $4,500 less than the lowest replacement cost that the evidence supported. And so my point in asking whether it was excessive or inadequate is, how could we look at that and know necessarily one way or the other whether it was excessive or inadequate? If we grant you that it's not supported by the evidence of the two buckets as you positioned it, which makes a lot of sense, if it's right in the middle, how can we say it's excessive or it's inadequate, either one?
Well, Your Honor, as you pointed out, one of the primary things is that the jury, they didn't have to, but they specifically wrote for repairs. And at one point during deliberations, they sent a question back out asking for citizens expert Mr. Green's assessment on the cost estimate, but there was no physical estimate to give. The judge instructed the jury to just rely on their memory and their notes of the testimony that was given. And he was the person who was the only one who gave a cost of repair estimate other than replacing the entire roof. And here, as the fourth DCA stated in United versus Cologne, the plaintiff has the burden to prove a specific and definite amount of economic damages. And in fact, the jury was instructed in this case that the plaintiff had the burden to prove both the method and the cost of repairs. And so simply put, not only does common sense instruct us that if all parties agree that $9,700 is the cheapest you can replace the entire roof, any amount less than that means the jury did not think that the entire roof needed to be replaced, in addition to them writing the for repairs. But it also means that they have to rely on the evidence. And in this case, there was no evidence that you could replace half a roof. In fact,
isn't there testimony from was it James, I guess the Looney's expert, even though he gave testimony about replacing the roof, and I think his company provided 3 different estimates, but at the beginning of his testimony, he says, "I'm here to testify about the cost to repair." So how do we know that when the jury writes for repairs that they necessarily mean some kind of spot repair or less than replacement, as opposed to repair in a more general sense, meaning replace the whole roof? In other words, if they blew the dollar amount so drastically, how can we then conclude that they were really clear about the distinction between a spot repair and a replacement?
well, Your Honor, to not give context to the word repairs, if repairs meant anything they could possibly do to the roof, then there'd really be no point in the jury writing anything at all. There'd be nothing to distinguish. Any dollar amount they award.
Which leads to the question, the case law that suggests when the jury writes something that they're not asked to write, we just treat it as surplusage. Because the verdict form here didn't ask them to say whether you want to award damages for repair or replacement. It just said, how much are you giving them? Why wouldn't we just treat that for repair statement as surplusage and disregard it?
Your Honor, we shouldn't disregard it because this court is allowed to to alter a verdict to conform with their intent. So this is evidence of the intent, but even without the word for repairs, the $5,000, as I said, is just not indicative that the roof needed to be replaced. And the jury is not entitled to speculate or provide guesswork. Their job is to, especially in the case of economic damages, to award an amount that is consistent with the evidence. And there was, again, no evidence that half of the roof could be replaced. And it's clear, I believe, that they did not find roof replacement. So since they did not find roof replacement, then it must revert to whatever the maximum amount in evidence for something else was. And in this case, that was the spot repair identified by Mr. Wen, which Mr. Green identified would cost a minimum of $500. And again, this is the plaintiff's burden to prove both the method and the cost of repairs. And
That's interesting because, like, our last two cases, we did textual analysis of a statute and then I'm sure scintillating textual analysis of an insurance contract. This is just 6 people's driver's licenses, right? They write 4 repairs in there. You and I might sit here and think that we know what they mean. But in terms of following up to Judge Ganem's question, you've got the expert themselves referring to repairs and replacement interchangeably. There's an instance in the closing argument where that's done the same. How do we know what the jurors meant by 4 repairs if there was never an effort to ask them what they meant? You know, they're not legislators. They're not contractual draftsmen. They're just six people sitting there doing the best they can. How do we know what they meant by for repairs?
Your Honor, in this case, I think we have to look at the totality and use common sense because, like I said, if you treat the word repairs as meaning anything done to the roof, then there'd be absolutely no meaning to
But
writing.
what if I get
for-
together six fifth graders and ask them what the numbers after five are? Are they going to say the exact same thing that 70-year-olds would say about it in exactly the same cadence? What if I ask a bunch of high schoolers what they mean by "it's been a minute since I've seen you"? Do they mean 60 seconds or do they mean a much longer period of time? This is what I'm driving at. I think you're probably right that for repairs means for repairs, but if we don't know and we've got this case law that suggests that we just disregard it because they weren't specifically asked to do it, where does that leave you?
Well, Your Honor, like I said, I think it still leaves us with an excessive verdict because you can't replace half a roof. Common sense dictates, again, that the jury, if they thought the roof needed to be replaced in its entirety, would have awarded at least $9,700. Both parties submitted cost estimates on the cost of repair. So in total, there were 6 numbers ranging from almost $9,700 to almost $25,000. So
But Counsel, can't we also just say if the jury had really wanted to make an award for repairs, they certainly wouldn't have awarded more than 500 because that's all that the evidence supported for repairs.
Not necessarily, Your Honor, but in this case, if they did want to make an award for repairs, and I do believe it's clear that they did not believe that the entire roof needed to be replaced, then the only default that they have is to go back to what the evidence presented. And again, the plaintiff was very adamant that the entire roof needed to be replaced. And this was a strategic decision by them. They could have very easily did what Citizens did. Citizens maintained from opening statements through trial all the way through closing statement that there was no cover damage whatsoever. But they still had their experts opine on a smaller possible single shingle or single shingle tabs worth of damage that could have possibly been by wind damage in case the jury didn't want to award nothing. And then they also presented their own cost estimates for an entire roof replacement, so they weren't left with those numbers. In this case, the Loonies could have very easily done something other than be adamant that the entire roof could have been replaced. They could have provided their own alternative to repairs for the small spot repair identified by Mr. Wynn. They did not even cross-examine Mr. Green's $500 amount when he said a minimum of $500 to figure out what the maximum of that could have been. They also...
Can I go back to Judge Gamm's first question to start this away? I thought it was an especially good one because, and it follows up with how my last line of inquiry went. If we drop the words "for repairs" out of that verdict form, and I know you don't want to, but just assume for me the sake that it's not there, and it's sitting there dead in the middle of 500 and 9,500, isn't additor every bit as important as possible as remitter? And if so, then how is it an abuse of discretion not to give remitter?
Your Honor, I don't believe that it's every bit as possible as remitter in this case. And again, it's falling back on this principle that you can't replace half a roof, but you can theoretically repair a much larger portion of the roof than the small spot repair identified by Mr.
Let me give
Wynn.
you an example about how it might not be. What if you had some jurors in there that just said, you know, the lowest estimate on that is 9,500, but I got a cousin who could do it for 5,000. And I know I'm not supposed to entertain this particular evidence and all that sort of stuff, but you know, those experts seemed a little bit sketchy to me. So let's just do 5,000. Or what if the verdict is a reflection of compromise among those 6 people, some of whom want to repair and some of whom want to replace? That would seem to me to be the basis for a motion for new trial based on lack of competent substantial evidence for damages, but perhaps it's not suited for a discretionary review of remitter or additor. Do you see where I'm going with this?
Yes, Your Honor, I see where you're going with this. However, again, our position is still that based on the evidence, and again, you know, we've done a lot of theoretical talking about the words "for repair" not being there, but going back to your early example about how different things mean different things for different people, in all of those instances, though they may mean something different, everybody's meaning means something. to assign the word repairs meaning everything, and for them to make that distinction on the jury form means that they meant something by repairs. And if they meant whatever you do to the roof is a repair, then it doesn't mean anything at all. It would be assigning no meaning to their additional language. And again, I think it's far more likely that they, maybe they misremembered the numbers for repairs. Perhaps they were trying to split the baby. I'm not sure, but most likely they're trying to award something for repairs more than what the estimate showed. And again, they didn't have the benefit of Mr. Green's estimate back there with them. There's really only 1-0 difference between what he said and what they ended up awarding. But ultimately, again, this really just comes down to the evidence that was presented in this case. And again, it was the plaintiff's burden for method and cost of repairs. And if they wanted the jury to be able to award $5,000, Mr. Funderburk, for example, said at one point that 58% of the roof was damaged. Even though he was adamant it had to be fully replaced, they could have, just as Citizens did, alternatively mentioned some sort of cost for a repair to 58% of the roof while still maintaining that it couldn't be done, and perhaps that could have come out to something like $5,000. But instead, they put all of their eggs in this one basket of replacement. So when the jury doesn't find that it has to be replaced, it necessarily has to revert back to what the evidence showed. And in this case, that was $500. And unless you have any further questions, I'll go ahead and reserve the rest of my time for rebuttal. I ask that this court grant remitted to $500. Thank you.
Thank you, counsel.
Good morning, Your Honors. Can you hear me clearly?
Yes.
Okay. My name is Matthew Mullinax, and I represent the appellees, Mr. and Mrs. Looney. By way of background, I was also the trial counsel and have represented them from inception through today. Now, with that, Your Honors, one thing I wanted to say, well, as I'm here, what we're asking the court to do is essentially to affirm the trial court's denial of Citizens' motion for remittiture and then uphold the jury's verdict of $5,000 in covered damage.
Counsel, do you agree that the number 5,000 is not supported by any of the evidence in this case?
I would disagree, Your Honor.
And why? How can you get there reasonably based on the evidence that was before the trial court?
There are multiple ways, and that's part of the reason why I believe it would be improper to speculate as to what the jury might have thought. So one way, I'll say the defendant's expert on damages, Mr. Alan Green, said, and this sentence is important, so I'll read it. His only testimony as to the cost of repairs, it's one sentence, it's 12 words. It would probably be minimum charge for most roofers of about $500. So 12 words, 4 of them are qualifiers, probably, minimum, most, about. So even he is not specific, and he basically sets the floor at what a repair could be. Now with that, we have $5,000. It's clearly a 10x multiple of 500. So Mr. Funderburk, which was plaintiff's causation, so my client's causation expert, testified that there were 24 damaged shingles at the time of his inspection, 36 at the time of trial. Defendant's causation expert, Mr. Wynn, both of them were engineers, he testified there was 1 wind damaged shingle on the roof. So despite Citizens saying no coverage, no covered peril, their expert said 1 wind damaged shingle. If the jury were to have determined, they also had photographs and evidence that 10 different shingles on areas of the roof were damaged, it would be very easier plausible for them to say $500 for a repair. Citizens says it's 1. We believe there's 10 areas that need to be repaired. That's 5,000. I can give one other possible explanation.
Please.
Citizens damages expert also testified as to the cost to replace a square of a roof. So by way of background, roofers commonly refer to a square as a 10 by 10 section. And I don't think that that's in dispute under any of the experts here. That would be 100 square feet of the roof. So when you're speaking about a roof that's say 3,400 square feet, you would say it's 34 squares. Mr. Green, Citizens damages expert, testified it would be $500 to replace 1 square of the roof. He used that math to say, this is how I came to my cost to replace the entire roof, 34.4 squares times $500. So with that, if the jury were to have determined that 10 squares, so 1,000 square feet of the roof, which is approximately 1/3 of the roof, needed to be repaired, it could have very easily said $500 a square, $5,000. That would also match with Mr. Funderburk's testimony that 24 to 36 different shingles were damaged. And I believe he said that was 7 slopes of the roof. So a slope being you have all different angles. And his testimony was that in order to properly repair one damaged shingle, because of the brittleness and the age, you would have to take it up to the ridge, which Citizens expert also testified. In order to properly do that, you'd have to take it up to the ridge. So it's potential that the jury determined, okay, we're going to do 10 squares times $500.
So is it your argument that regardless of whether or not they wrote this for repairs notation, if they had just simply returned a verdict form that said $5,000, it's your position that's supportable, but that's reasonably supported by the evidence in the case?
Correct. I don't believe that it's contrary to the manifest weight of the evidence. It's squarely within the numbers that were presented, roughly 8 total, I believe, actual numbers. And it's actually closer to the $0 amount that Citizens have requested in this case. If I can make one try. Okay. I didn't want to interrupt if you had a follow-up question. So with that, there's been much position by Citizens to say that the jury made a determination that repairs were the proper method or that the repairs needed to be made. I would present to the court that the jury was never tasked with determining whether to repair or replace, and they were not tasked with determining the method of repair of this roof. They were simply tasked with determining the amount.
What are the instruction? I believe the language that the judge used was you have to decide, how much to repair or restore.
Correct. And I have that.
Can we not interpret that as asking the juror the question that they perhaps answered by writing, for repairs, where they could have written, some other number to restore, but they picked this number for repair?
Yes, Your Honor. So that jury instruction asked them to, and I believe this is a quote, consider only the reasonable cost of repairing or restoring, and I would end quote. And then the verdict form did not ask repair or restore or replace. It simply said, what is the amount of covered damages? And so with that, Your Honor, I don't believe that the jury, one, was tasked, but two, would have been aware that they were deciding the proper method to repair this roof. I believe that it was simply presented to them, what is the cost to do that? And so when we here and in the briefs are heavily disputing whether it was a repair or a replacement, the fact that the jury was never given the word replace, it was simply repair or restore. You now have a third word that's put in the mix. And I do believe that the lay people, the term repair of a roof might commonly be interchanged with replacing the roof. Thank you. So with that, Your Honor, I did address the different numbers that were presented to the jury. Ultimately, there were 6 different numbers for a full roof replacement. 4 of them were from plaintiff's damages expert. 2 of them were for Mr. James. 2 of them were from Mr. Green, Citizens damages expert. And the reason for that is the jury was given 2020 numbers at the time of the loss, 2024 numbers at the time of trial, and then plaintiff's expert, Mr. James, also delineated into actual cash value and replacement cost value. So he had factored in depreciation. Then with that, the jury could have also taken the total replacement values, divided it by the number of square feet or the number of squares, and come up with their own assessment of what a 1 square replacement of the roof might have been. So again, I point that out to say that there were enough numbers presented to the jury that it is very difficult for us to determine how they came to that number. But it is definitely something that a reasonable person could come to by more than one method. The amount is not excessive. It does not put the loonies in a better position than they would have been had this contract been performed. Most of the cases cited to by defendant dealt with cases that were far in excess of the amounts both sought by plaintiffs and calculable by the evidence that was presented. Here we have a number that's actually less than what the plaintiffs sought and can be calculated by the evidence that was presented. As to abuse of discretion, I don't believe that that standard has been met in this matter. I believe that the trial court, the trial judge was present, heard the evidence, considered this on the motion for remitter, and with that, there should be broad discretion given to that judge. And as we look at this, I would say that it neither shocks the judicial conscience, the amount that was presented, nor does it manifestly contradict the evidence that was presented. If you bear with me, I just want to go through my notes and make sure I've hit my points. As to that verdict form, one other consideration, the policy has a deductible. It's a $1,000 deductible. That question was not posed on the verdict form. The jury was provided with the policy and evidence. So I bring that up because we are heavily considering how they arrived at 5,000. We don't know if they determined it was 6,000 and then applied that policy deductible. Preferably, you would have a verdict form that delineates how the jury arrived at their numbers. You could ask them replacement cost value, actual cash value. You could say with or without deductible. I think in the best case scenario, in a first party dispute like this, you would say, what is the replacement cost? What is the actual cost with or without deductible? And you tell the jury whether or not to apply that deductible. So as it sits here, we can presume that they determined 5,000 was the top end, but we don't know whether they actually determined 6,000 with that deductible. And then I would point that out as well, that with this verdict form, defendant could have sought more clarification. They could have sought for the jury to determine repair or replace. They could have sought those different numbers. The fourth question, I believe, on the verdict form. So in the jury coming to its determination, Citizens' position is that no liability existed and that the jury should therefore not even come to a determination on amount. Had the jury determined Citizens was correct, they would not have made it to the last question on amount. By determining that coverage existed, they made it to the last question, they gave that amount. So with this policy, there were two main defenses Citizens presented: pre-existing damage, wear and tear, and some other issues. The difference being pre-existing damage, had any portion of the damage been the result of pre-existing damage, the language of this policy says that even if you have covered damage, it's all excluded. The jury determined that didn't occur. The second or the fourth question, but the one directly before the jury answered the amount, asked if there was any wear and tear. Now, the distinction with this is it asks the jury, was the damage caused solely by wear and tear? The difference there is the jury could have determined that some or a lot of this damage was wear and tear, some was wind, and it would still be a covered peril. That also allows for the jury to have potentially determined that the roof needed to be replaced, but that a large portion of the roof was damaged due to wear and tear or an excluded peril, and that 5,000 was attributable to wind. I believe those were all the points I was going to make, unless your honors have any other questions.
Final question. If at the time that the verdict was delivered, if Citizens believed that there was a discrepancy between the 5,000 number and the notation for repairs, did Citizens have any recourse at that moment or even a duty at that moment to say something to the trial judge to attempt to get clarification from the jury about what they meant by that? Or would that have been improper at that point in time to go down that road?
I believe that you can always ask. If you have, then you have the benefit of the decision that the trial court made, and we would know whether that did or didn't happen. If you don't ask, and I say this as a trial litigant, it's hard to say later on that something should have been done because you didn't preserve that. So I do believe it was well within their ability. I think they could have. And I know in reading some of the cases that deal with abuse of discretion, one was the Ernie Hare Ford case, and the other was, I think, Brown versus the state of Stuckey. Those dealt with interviews of jurors after these awards were given. I know one of them even dealt with the jury came back with two different numbers. So there was essentially two counts, and it was very clear from the numbers that they had transposed them. So one was to the penny what one count was asking, and the other, like 11,192. The other one was 147,000. Even the judge said, we don't want to tell the jury what to think, but it appears as though you may have transposed these. Do you want to go back in the room and deliberate? Jury did. They came back out, but the problem was the total came to the same, but then they had two new numbers that you couldn't tell what they were. So at that point, the judge said, look, this is not so clear that I can tell them it was wrong or do anything. I think we have to let it sit. So I bring that up because I do think there's a vehicle where if one side thinks there's an error, there was an inaccuracy, there was confusion, this is against the manifest weight of the evidence. We don't know how they ever came to this. You could ask the judge to inquire to the jurors to some extent and see what happens there. I would also say, just from a more practical matter, it is not uncommon at all in cases like these to have, especially when you have a denied and you have a case where one side saying 0, one side saying this is our estimate, to have a number that comes in the middle. I've seen occasionally where the numbers go outside of it, but more often than not, in a first party breach of contract case, the jury is going to give some number that's between the two numbers.
Thank you, counsel.
Your Honor, just a couple points on rebuttal, starting with one of the last. It's not before this court whether citizens had the ability to ask what the jury intended by the $5,000, but there's certainly no preservation issue about their ability to still seek remittitor after the fact, remittitors for exactly these situations where we do not have an inconsistent verdict. An inconsistent verdict would be where they're mutually exclusive findings on the jury form. Something's obviously wrong. When that's not the case, you can always challenge for an excessive verdict by filing a motion for remittitor after the jury has already been discharged. And then at one point, he also said that it doesn't matter that the jury wasn't explicit, or excuse me, he said, talked about it, the jury not being explicitly asked repair or replacement, but that is a threshold question that's necessary to the jury's determination because they have to have a finding based on the evidence. In our briefing, we relied on the Appellate versus Exotic Tools case. There's a fourth DCA case where the contractor was hired to build a pool deck, a screened enclosure, and after the project was completed, there was a drainage issue which was discovered. And at trial, the plaintiff's position was the entire pool deck needs to be redone, replaced. It's going to cost $38,250. And the defendant's position was, well, we can resolve the drainage issue by installing a commercial drain for $1,500. And in that case, the trial court awarded $9,000 and the fourth DCA remanded because it had to fall under something that was supported by the evidence. It either had to be $1,500 or it had to be $38,250. And in this case, we have the range at the top, almost $9,700 to almost $25,000 or $500. The evidence doesn't support anything in between. Now,
Counsel, you talked about strategic decisions earlier, but I think citizens in this case made a strategic decision not to seek a new trial based on the verdict being against the manifest weight of the evidence, but to only ask for remittitor. Appellate or Appellate, however you say it, that would help you in the case of like, we just want a new trial on damages because this number of 5,000 right in the middle of the two buckets doesn't work. It's not supported by either range of the evidence. But in this case, you only asked for remittitor, and I believe Judge Traber asked about this earlier. That puts the trial court in an interesting position. If asked to give a new trial for damages, maybe it would be an abuse of discretion under Appellate for the trial court not to have done that here. But since you only asked for remittitor, we only have to say, well, is there any reasonable judge that could have said no to remittitor on these facts? And then the abuse of discretion standard is satisfied.
That's correct, Your Honor. We're here on the motion for remittitor rather than a motion for new trial, and the discretion, it is an abuse of discretion standard. However, like I said, the evidence still does not support $5,000. And our position is it's clear that.
Can I ask you about that? Because your colleague made an interesting point that I hadn't considered about the price per square. Could a reasonable jury have taken that mathematical calculation coupled with the testimony about the damages to the roof in terms of what percentage of the roof that it covered and come to that particular conclusion? We don't know what they meant about the deductible or not. It wasn't asked. But if you're in that 5,000 to 6,000 range and you're in that price per square, does that provide competent substantial evidence to support the determination?
No, Your Honor, it doesn't, because there was no evidence or testimony at trial that you could extrapolate those numbers in that manner. In fact, the only brief discussion on any method of repairing the roof somewhere between the spot replacement identified by citizens experts and the full replacement was Mr. Wynn, citizens expert, briefly discussing how a repair in a different part of the roof would change the calculus essentially of what the repair entailed. So in this case, especially since we don't know where the additional tiles identified by Mr. Funderbrook exactly are, and whether those and even if we did, whether those are in locations of the roof that require different kinds of repairs than simply maybe peeling off one shingle tab and replacing a shingle tab for the price of the shingle tab at $500. Because we don't have any of that information, it would require the jury to participate in speculation and guesswork in order to come to some sort of a conclusion about what it would look like to repair some other unidentified portion of the roof. And again, it is the Looney's burden in this case to prove, as the jury was instructed, both the method and the cost of repair. And so again, if they wanted the jury to be able to extrapolate out some larger amount of repairs, then they needed to give the jury the tools to do so. Citizens didn't give the tools to do in this case, and the Loonies didn't either. Therefore, the jury would be incapable of coming to this calculation by themselves. And I know he mentioned this idea of the wear and tear portion. However, the instruction was just that it's excluded if it's entirely based on wear and tear. The jury was not then instructed that if it's not excluded, then do your best to figure out how much was wear and tear and how much was attributable to the cover damage, and then assign some portion of this to the total and some portion to the wear and tear. They're restricted by what was presented. And again, what was presented was either $500 for this cost of repairing the small spot repair, the only thing we know the method and cost of repairing on that roof, or replacing the whole thing for somewhere between $9,700 and $25,000. And for these reasons, Citizens is entitled to remittitor in the amount of $500, and we respectfully request that this court reverse and remand. Thank you.
Thank you, counsel. All right, we will be in recess. Thank you.
All right, good morning. We'll be back on the record. This is our fourth and final case of the morning. We've switched out panels. I'm Dan Traver. I'm the Chief Judge. I'll be presiding. To my right, your left, the Honorable Jared Smith. To my left, your right, the Honorable Joshua Mize. This is Battaglia versus Battaglia, case number 23-1658. We had an oral argument on this case in April, and we issued our PCA that exact same month. Based on post-dispositional motion practice, though, we determined that we had misapprehended a stipulation we believed that had been accepted at our last oral argument. And based on that misapprehension alone, we have reset OA for today. In our notice, we advised the parties that the OA today is limited to the damages issue that is raised in issue 2 of appellant's initial brief. More specifically, the panel is interested in the argument raised on pages 59 and 60 of the amended initial brief, which is section 2C2, and which relates to an alleged double recovery on the part of the trust. This is addressed on pages 40 through 42 of the answer brief and page 27 of the reply brief. We also asked the parties to be prepared to discuss section 607.750 of the Florida statutes. Nobody here needs reminding that we are not an evidentiary court. We don't weigh credibility. We cabin our proceeding to the record that's before us. That said, we wish to highlight our intention not to consider any matters that fall outside the voluminous record that we have now twice reviewed, and we expect counsel today to abide by that intention. Mr. Brownlee, how much would you like for rebuttal? Whenever you're ready, sir.
May it please the court. My name is Mike Brownlee. I'm here on behalf of the appellant, Bill Battaglia. And Yogi Berra once said, it's like deja vu all over again. Here we are again. Kidding aside, want to thank the court really for taking the time to do this again. I know how busy the court is. I know how precious argument time is. I know two of you have traveled a long way to come here. Really, really appreciate it, trying to get this right. It's really important to my client, obviously, so thank you. So we're here to talk damages. Our position remains the same. Damages award should be vacated in full because it is exclusively predicated on corporate actions or inactions and not on trustee duties. And that's prohibited under Parker versus Schulman, which is 906 Southern 2nd, 1236, and the other authorities we cited in our brief.
So let me take the big ticket items first as it relates to the BFCIC and BPL money. So you've got a factual finding in the judgment that money is sitting in the BFCIC and BPL accounts. So is your argument going to be that money effectively is eligible by the result of the trial court's, the rest of its judgment, which I know you disagree with, but we're not hearing about today, that is effectively going to be covered so that any subsequent judgment collection on those dollar items would effectuate a windfall on behalf of the opposing side of the case?
Well, certainly. But I mean, I think the threshold issue is that those are corporate funds that require corporate actions and, the whole panoply of rights under the corporate statutes that were never at play in this case because this was a trust case. There was no corporate.
There's two issues in my mind. There's that, right? And I get your argument on that these were not damages for the capacity in which he was sued, right?
Correct.
The separate argument is, regardless of whether these damages relate to this capacity, they still have the money, right? Like, just as a factual matter, the judgment found the money is there.
Correct. No one's
right?
out. No one's out anything.
Which of those two issues is the much easier issue?
I think the first one. I mean,
Really?
I know the court is interested in the second one.
Really? The fact that's easier than the money's still there?
It is in the sense that there was no corporate anything pled or proven to the case. The first time that we realized this corporate stuff is happening is in the final judgment. So, I mean, should never have been even at issue.
But what I guess
It's
what
his
I'm
duties
saying,
as a
what I'm saying
trustee.
is the capacity in which he sued is a legal issue on which we must decide, right? And the two of you dispute it.
Right,
The final judgment itself found the money's still there.
right.
You don't agree?
So there's no damage to the trust.
Exactly, right?
That's-
There is no, regardless of what capacity, these actions were committed in or how we would resolve that legally,
Correct,
the money is still there.
correct. I thought you were going down the road of satisfaction or something like that.
No. I'm just
100
saying there
100%.
are no damages because the money is still there.
Yes, the statute requires really clearly that there be damage to the trust, either a loss or something that can be restored.
Yes. So okay, now that you understand what I meant by that,
Understood.
between those two issues, is that not the easier issue? Before you get to the capacity of damages, the money is still there.
Correct. The lack of damages to the trust, i.e. there's no money lost, that's been our argument this whole time.
I want to ask about, unless anyone has any more questions about those items, about the smaller ticket items, the attorney's fees and the interest on the attorney's fees.
Sure.
Did you take a look at 6070750?
I did.
So I went down a rabbit hole on that. And what I found is that it is, because I think you recall at the last oral argument, I asked both sides about how this works under traditional principles of corporate law, right? And the fact that these are in fact distinct entities.
Right.
And I went down a rabbit hole on that and found this provision, which seems to be wholly unique to Florida. I can find this I can't promise I scoured every inch of every corporate code, but I did a pretty deep dive. And this subsection B, I cannot find in any other state's corporate code.
Right.
And when I went to look what it was actually, before it was in the corporate code, it seems like it was just invented by courts that made Florida, judicially created, right or wrong. The judiciary created this provision that really set us apart from how traditional corporate law works in every other state, right? And how you would view it. And then what happened was the legislature codified it, right?
I think correct.
That brings into play the prior construction panel and the prior construction canon. And if they're codifying judicial language, you take it to mean they were pretty much trying to codify the cases that use that language. So I'm not saying that this is consistent with traditional notions of corporate law. I'm saying that it appears that Florida, rightly or wrongly, may have created some very weird exception to traditional notions of corporate law, and then the legislature, in their judgment, codified it. And when I went back through the history of this provision before it was codified and all the cases where it was created and then applied, it seemed to be relevant to these types of situations where somebody may owe a duty in two different capacities, and normally you would split those capacities and say they're distinct. But with this particular provision and how the courts interpreted it, before it was codified, how they created it, that if some corporate officer owed you a duty from some other capacity unrelated to their corporate capacity, that would color how they would have to answer their corporate duties, perform their corporate duties, and potentially could make you liable under that other duty. I don't think that's relevant to the double recovery because the money's either there or it's not, and the final judgment's not there. But it would seem relevant to me to that $150,000 and the $3,000 in interest. So can you tell me what you found on 6070750?
Sure. I concur that it's a weird statute. And I think it's designed to be an end around the derivative suit requirements. That's the best sort of guess I could do by the reading of it. But there are two really good reasons it doesn't apply in this case, or shouldn't. The first is the procedural history of this case is really important to remember. So they sue in a 3-count complaint. First count is for removal as a trustee. Second count is for breach of trustee duties. Third count is against BFCIC and against Bill as in his stead as a corporate officer and director, challenging his corporate decision-making.
I think what you're going to say is they didn't sue him as a corporate officer, but that's my point. This provision seems to say you can sue a corporate officer in some other capacity,
Right.
right?
Okay.
Because of some other statutory duty.
Correct. But here's what happened. In response to that complaint, we moved to dismiss count 3, the corporate stuff, for failure to file a derivative action. And in response to that, Bob did not turn around and say, hey, this 6070750, it allows us to do this. We're good. He filed.
They're appellee, right? We can tipsy coach them. I mean, this is a purely legal issue.
That would, Judge Mize, that would be respectfully a huge violation of due process, of my client's due process rights. Here's why. Because when we moved to dismiss for failure to file a derivative action, They don't say this statute helps us or we're allowed to do this under this statute. They file a notice, and it's on page 265 of the record. They file a notice of abandonment of the claim against
But that
involving
only
all
matters
corporate
if
stuff.
they needed that claim. And what I'm saying is that this provision seems to indicate they did not need the claim against them in his corporate capacity. And I think what you're saying, that they could actually do this in his trustee capacity. Like, I agree, it's a bizarre provision. I could find it in no other state, right? It seems to completely be counter to how we think of corporate law. It's in there.
Judge Mice, throughout the case, I'm sorry to interrupt you.
No, go ahead.
Throughout the case, every time my client tried to defend anything he did at the corporate level, there was an immediate objection from Mr. Spivey saying, this isn't a corporate case. Corporate actions aren't relevant here. Sustained. There were 3 pretrial rulings from Judge Jordan that said, this is not a corporate case. This is a trust case. Only trustee duties are at issue. So if we're going to come back now and read into the record something that allowed them to bring up all this corporate stuff, we didn't have a chance to defend.
Well, let me ask you, I mean,
It was never an issue.
I get your concern about due process. What that would essentially mean is that if an appellee didn't raise some legal argument below, that they can't raise it with us. And that's just not what the Supreme Court's Tipsy Coachman jurisprudence says.
Judge Mice, that would be a massive violation of the party presentation doctrine. This court cannot be standby counsel for the appellee. And
Well-
Mr. Spivey is paid.
The party presentation applies to the appellant, not the appellee, right? I mean, there's a slew of cases from the Supreme Court and across the DCA saying not just that we should, but we must affirm if there is any basis in the record, right? And now, oftentimes that's not clear, right? Maybe you need a factual finding, maybe you don't. What exactly is supported by the record? Here, though, this is a purely legal issue.
No, Judge Mice, if someone had said, in this case, this statute allows us to do what we're trying to do, there would have been findings. That would have initiated the business judgment rule under corporate law. That would have allowed my client to take in advance of his legal fees. That would have changed the entire scope of litigation. Tipsy Coachman requires that it be in the record, established in the record. This is the opposite of that.
Mr. Brownlee, I think what you're taking is if that had been the track they took, then we would have gone down the corporate duty route, and this would have been a corporate claim.
Correct.
And I guess what I'm saying is this provision, which I stipulate, is very weird, totally unique to Florida, and out of step with how corporate and derivative actions seem, how we normally think of them working. Okay. It seems to say you can go after corporate duties in some type of claim that arises from something outside corporate obligations, such as trust obligations.
But only if, look at subsection 2. A shareholder maintaining a direct action under this section must plead and prove either. Must plead and prove. The opposite of pleading this occurred. They waived it. They pulled the count back. So the plain language of the statute makes it clear it cannot apply here because it was not pled or proven. The opposite happened. It was waived. They abandoned that claim. They abandoned any effort or ability to defend or prosecute the case on anything involving corporate anything. So the plain language of the statute, subsection 2, it does not apply. Again, based on the arguments we've made throughout the case, in either of the 2 formulations of the damages problems with affirming the damages argument, I think either one works in our favor, and I'll request the remainder of my time for rebuttal, unless the board has any more questions. Okay. Thank you.
Good morning. May it please the court, Bill Spivey of Greenberg Traurig with Courtney Keller on behalf of Robert Battaglia, who I may refer to as Bob this morning. I think the court at the trial court level got this right, and I think you got it right as well in the PCA. Let me speak relative to this damage issue to a very interesting point that jumps out at you if you go back and read carefully the appellant's initial brief. It's at page 50 of the initial brief. He completely skips paragraphs 82, 3, and 4, I believe, of the final judgment. And that's where Judge Jordan talked about Bill Battaglia having a conflict of interest in that he breached the duty of loyalty. And that's a critical component that would sustain this damage award if you get into the case law under duty of loyalty. And more specifically, if you look at the 2023 Trust Code, Section 802G, there's a comment that reads as follows. A trustee whose duty of impartiality would require the trustee to make current distributions for the support of current beneficiaries may not evade that duty by holding assets in a corporate form and pleading the discretion of corporate directors to determine dividend policy. And I think that directly addresses the circumstance that we're dealing with here. Bill Battaglia had manifest conflicts of interest. The record is
So
clear.
you're getting your damages under 736-1002.
Yes, sir.
Correct. So you're dropping 1B off the table, I would assume?
Yes, sir.
Okay, so we're under 1A. The amount required to restore the value of the trust property and trust distributions to what they would have been if the breach had not occurred. So I guess I'd kind of harken back, whether you look at it as a double recovery or whether you look at it as the money still being there. The oddity to me is that the numbers match. You know, your argument seems to be placing an identical value on the opposing party's breach of trust as is contained in BFCIC's coffers and in BPL's coffers. Strikes me maybe that argument would have a little bit more traction to it if it were a different number, say $50,000 or $100,000 or $500,000. I struggle with what I think your argument is, which is the trust has been harmed by the exact same dollar number that's available to the trust through BFCIC and BPL.
Remember that we're suing, Bob Battaglia individually is suing. And the money should have,
Individually and on behalf of the trust.
individually and as co-trustee of
Yes.
the trust. But the money should have been in Bob Battaglia's personal account through a distribution that Bill Battaglia unilaterally had the ability to implement. And the record is clear that Bill Battaglia dipped into BFCIC and other corporate funds whenever he wanted to. And ironically, I think that the disconnect that brings us here is this partial satisfaction of judgment.
Not interested.
Yeah, counsel. So
I
I mean, what you're basically saying is, well, the money was within the trust's assets, right? It was within BFCIC, and he had the ability to get it to me, and he didn't, right? But that's akin to like, you know, you're in a divorce. We've got a joint bank account. The other person, you know, won't release money to me. You don't get an order for them to, you know, pay you the money personally, and also still get to keep the money in the joint bank account. Like, the money is still there. At least this pot of funds, I mean, you can say he dipped in for other things. This pot of funds is still there, and either it's able to be distributed or it's within BFCIC holding value to BFCIC, right? And thereby increasing the value of the trust by that exact dollar amount.
But it should have been distributed years prior to it still being there. And it should have been in Bob Battaglia's account.
Take the joint bank account example, right? You're in a divorce and you say, Judge, the spouse should have given me this $1 million 2 years ago, right? Or 5 years ago. He or she has been holding up the money. It's my money. And if the judge said, okay, the judge wouldn't say, yes, pay them your half of that money personally, and also you get to keep the half in the joint bank account. Like this, nothing you're saying, you know, does anything to deal with the fact that that money is still there. It's within the assets of the trust, and when distributions happen, that money will come up.
But it should have happened much earlier, and it should have happened without litigation. And the defendant should not be able to now come forward, oh, but there's no damage because I sat on it for 5 years.
He's not saying there's no damage. He's saying you're getting double damage by getting a personal payment and also the money still being within the trust. Nothing you're saying to us is responsive to the fact that this results in a double recovery. The money is still there.
I think if the statute spoke more towards penalties as opposed to restoration of value, maybe this would resonate a little bit more. But if I'm just looking at the plain language of 1A, it's not talking about bad co-trustee. You know, you should be penalized for this. It seems like if you're making a time value of money argument, that wouldn't be the entire to the penny amount of that value.
course not. But if you look at this statute, 1002A1, it says restore the trust distributions to what they would have been had the breach not occurred, including lost income that would have resulted from proper administration. And the record is clear that Bill Battaglia engaged in gross trust administration.
But counsel, what stops that distribution from still happening?
It theoretically could in the future, but it should have happened 5 years ago, voluntarily.
If that happens, will your client get a double recovery?
No.
How? He got the money from Bill, and now he's also going to get the distribution for the same amount. How is that not a double recovery?
We haven't gotten any money from Bill.
Okay. If you were to be able to enforce this judgment in the manner you're arguing, don't avoid the question, and the distribution happens, will your client not have gotten the same money twice?
Not necessarily. I think the judgment is against Bill individually because of his misconduct. And now I think you are saying, well, just dip into the corporate funds and then you'll be fine.
But this pot of money was, these are the corporate funds I should have received. Is
Yes.
it not? Okay. So the funds to which that is referring are still there. So if he receives them through a distribution, albeit late, right? Maybe it doesn't happen when you say it should have happened, but those funds ultimately will have come up to Bob. We're using first names because they share the same last name. They would have come up to Bob, and also he would have gotten those same corporate funds from Bill, would he not?
I think that's right, Judge.
Okay.
I think you're right.
So there's a double recovery here.
There could be a double recovery. There could be.
If the money does not come up through a distribution, it's still going to be in BFCIC, correct?
Yes, sir.
BFCIC is an asset of the trust?
We
Or,
own,
the shares of it was 77%.
we own 78% of it,
Yeah,
yes, sir.
78% of it. If a company, if you have one company and you have the same company with $2 million in its bank account, is that company worth $2 million more?
I'm not sure I'm following you. I'm sorry.
You have one company, whatever the status is, whatever assets it has, same company, only it has $2 million in a bank account. Is that company's value $2 million higher than if it didn't have that $2 million?
Yes. Yes. I don't know if you have any other questions of me relative to the damage issue. I think that the ruling below was correct. At a bare minimum, if this court is inclined to reverse on any form of the damages, Bill Battaglia is still liable for at least nominal damages. And there's just not a complete walkaway that he gets from this. There was some egregious misconduct that was adjudicated by the trial court. And at a bare minimum, my client's entitled to nominal damages.
Do you have any thoughts on the corporate code provision that Judge Mize and Mr.
I think it's
Brown were
interesting.
discussing?
I think it's very interesting. My point in saying I think there's another way to get there, and it's 736.08026. And if you look at this 2023 comment on
Can you just give that number one more time?
the statute is 736.0802 subpart 6. And I'm now referring to the Uniform Trust Code comment G under section 802G that talks about a trustee whose duty of impartiality requires him to make current distributions cannot invoke this corporate defense, if you will. And there's other case law that talks of a fiduciary that has a conflicting interest. You don't then get to invoke the business judgment rule. You don't get to invoke these niceties because you've trampled the niceties. When you found it good for you to trample the niceties, you did. So a court of equity will not enable that person to now come forward and go, oh, wait, I need to invoke these corporate niceties. I need to invoke the corporate formalities. You've run roughshod over them for years. You're not entitled to do that. So to answer your question, Judge, that statute is very interesting, the corporate statute. but I think you can get there the same way through 736.0802, which then ties into 736.1002A. 1.
Do you find Mr. Brownlee's plead and prove comment as it relates to the preparatory part of sub 2 to have any value to it? Because it doesn't seem like it was pled.
It wasn't pled. We did not utilize that statute. The statute became effective only 6 months before the lawsuit was filed. We did not use it. But I think the concept in it is applicable to this case under the tipsy coachman rationale.
Well, and I'll ask Mr. Brownlee this when he gets back up, but it says plead and prove an actual or threatened injury resulting from a violation of a separate statutory duty, right? So that seems to say what you have to plead and prove is the non-corporate statutory duty, like a trust duty. Anyways, that's, go ahead.
But I think the legislation points to the fact that there can be liability in different capacities. And I think that existed prior to the enactment of the legislation. I think under equitable principles and other principles that we allege in this case, you could also be liable for these things. And I think that the lower court got it right, and I think you did too.
Thank you.
Thank you.
May it please the court. Your Honor, so it wasn't pled, it wasn't proven.
Mr.
It
Brownlee,
was literally
if you'd
waived.
rather spend your time on the $2 million, I won't begrudge you, because obviously 153 is a smaller piece of it. So if you want to not use your time like this, it's your time. I won't begrudge you. Okay, but I'm interested in it because it says the whole point of this seems to say you can sue corporate officers for other duties that normally you would only be able to sue them in their capacity as a corporate officer. It seems to say that if they owe you some other duty, you could sue them under that duty, under that capacity for corporate actions. And when it says plead and prove, it says you must plead and prove an actual or threatened injury resulting from violation of a separate statutory duty, meaning separate from the corporate duty. So it seems to say what you can do is bring a statutory duty claim, like a trust duty claim, right? Plead and prove the trust duty claim, but hold them liable for actions taken as a corporate officer, which I agree is strange. I'm not saying it's not a bizarre provision, but it says plead and prove a separate duty from the corporate duty, doesn't it?
Judge Mice, it does, but Mr. Spivey just told you it wasn't pled. They never considered this. They never considered the statute. For tipsy coachman to apply, it has to be established in the record. It is the opposite of that, because when we moved to dismiss and said you have to file a derivative action if you want to talk about any of this corporate stuff, they abandoned the corporate stuff. And it doesn't show up again until the final judgment, which is why we think Judge Jordan didn't scrutinize the final judgment, because he didn't make an edit to it. And all this stuff that he said was not at issue comes up again.
You know, what's interesting about the statute, which I think we've got a plurality at least on weirdness, as it relates to referencing a separate statutory or contractual duty. So in that sense, I don't know, and you know, we ask questions, we don't make suppositions, but to the extent that that's a supposition, that this refers to something separate, contractual to me would seem to be driving the notion that you wouldn't have to plead effectively this end run around the derivative statute, so that you could anchor it in some other form of recovery.
Perhaps, but we don't. There are no findings because none of this was ever argued before. I mean, this is getting. We're getting off the reservation for tipsy coachman. This is not what this is.
Mr. Rumley, I agree that when you need when something requires a factual finding, we cannot tipsy coach it on that basis unless the factual finding is in the record. I'm with you on that. Okay. But it's not true that we can't tipsy coachman based on a legal argument that the appellee did not make, right? We can tipsy coachman, and the Supreme Court tells, this is good, whether it's a good idea or not, the Supreme Court tells us to tipsy coachman based on legal arguments that were not raised, as long as the basis for the legal argument is on the record. The legal argument didn't have to be made. Right?
I disagree with that. I think the Supreme Court says you have discretion in limited circumstances to do that. And Mr. Spivey, no one said, hey, there's a separate reason for affirmance here. It's a different reason from the court. I mean, we're really far past the party presentation doctrine, which the Supreme Court is, the current iteration of the Supreme Court has talked way more
Party presentation
about.
doctrine only applies to appellants.
That is, I disagree with that, Judge Weiss. I do. And we can file, if the court is serious about affirming any of this on the basis of this statute that was never pled or proven, then we would respectfully request leave to file some sort of memorandum.
You're telling me your position is that a appellate court in Florida cannot affirm based on any legal argument not made in the appellee's brief?
I think no, you definitely have discretion to do that. I'm saying there's no duty, and that's supposed to be in very limited circumstances, and it's supposed to be when the appellee points it out to the court. A sua sponte application.
No, but that would mean it's in the appellee's brief, right? What I'm telling you is it your position that if it's not in the appellee's brief, it's a legal argument that's not in the appellee's brief, we can't affirm based on it?
I think there are very limited circumstances where you can, based on my reading of what I know about tipsy coachman. But if this is actually happening, then we'd respectfully just like leave to file a memo of some sort, at least, to convince the court otherwise, since it's coming up now for the first time.
Can I, if there's a,
Please.
I think we spend time on this issue, at least from my perspective. Can I ask you to address your motion for reconsideration of the fees?
Yes.
What is your best case that this changes the, I mean, obviously the bigger issue in the case was removal, it seems like, right? What is your best case as opposed to damages? Assuming that if we were to agree and reverse the $2 million damages award, what is your best case that the fee order should be changed?
It's not necessarily a prevailing party fee statute, right? It gives the court, where you're sitting in equity, it gives the court discretion to take the equities into consideration. We've been arguing since the jump that the damages were not possible. I don't know if, saying whether removal was bigger than damages. I mean, if you have a $2 million damage award against you personally, I think that's a pretty big deal, maybe more so than the removal, but that would make it such that we prevailed on a major issue in the litigation for the reasons we've been saying since the jump, since the trial court level. And there's no reason we should have to subsidize the other side's legal efforts when we win in a major argument.
Two minds on this. In one mind, to me, the major issue of this case was certainly who has control over this family trust, which had $70 million of assets or thereabouts. And certainly if I, go from the comments at the beginning of the OA today, the issue that we're here back on is 6 pages out of 203 pages of briefing. It's an enormous record. A lot of work was put in on both sides on this. On the second hand, we've made you guys come back for a second argument on OA, and I presume that you guys are prepared for all of that. It seems to me that as it relates to figuring out a case where we have a party prevailing on one issue and a party prevailing on the other issue, we weigh some equities. And I wonder if, given that backdrop of my two minds on this, if you couldn't help me understand which side of my brain I should be listening to.
The side that helps us, of course. So, Judge Schrager, I think when you delineate the briefing, 6 pages of the briefing is on damages. It's a little bit, I don't know that that's exactly right, because a lot of that incorporates stuff about removal. I mean, a huge part of our removal argument was, hey, this is all corporate stuff he's being removed for, not trustee stuff. It has nothing to do with his trustee duties. And that's a big part of that damages argument. So all that facts and all the stuff that we argued removal, I don't know if we specifically incorporated that by reference in the damages argument, but I think we came close.
Well, I mean, if he's not removed, then there's no damages, and that's
Right.
yeah.
Yeah.
So, and I get
so
that.
it just bleeds over.
But there were bases for removal other than corporate other than
There was one, which was a failure to file accountings, which was also Bob's duty.
Well, what I'm saying is though that the fact that the fact that he was removed, portions of their claims for removal were related to alleged breach of duties, but there were some reasons they gave for removal that did not pertain to breach duties, just based on like lack of cooperation, right? That was when we talked about the last oral argument. So it's not like just the fact that the removal is upheld completely resolves the damages issue on that, right? Because
No, they're different.
You still have to determine whether or not damages came from that would still be a live issue.
Sure. Yeah.
Right.
I was just speaking to the idea that only 6 pages of the briefing were about damages. I don't think that's really a fair characterization of what had to go into the damages argument to get you there. That's all. And also, we're back at the second oral argument, not because of anything my client did, none. So also to have to pay for all that
all their fees associated with this. That's also not fair. I hate saying not fair. It's barred my house, but like, it's not fair. Shouldn't happen. And if he wins on damages and we're back here because of Mr. Spivey or Bob or however you want to put it, we shouldn't have to subsidize that. We shouldn't. So the court should, whether it's a full scale, reconsideration of that.
Is that theoretically something that could be argued in the lower tribunal as it relates to amount and
I hope
reasonability
not.
as opposed to entitlement?
I-
Just in terms of thinking about it, and I'll go back to the family law sort of situation again. You can go back and just because you have entitlement ultimately, and I understand that there was an agreement on the trial fees,
The amount.
but as it relates to lower court determination of what the amount is, isn't that what that last part that you just said, the not fair part, isn't that something that the trial court could take into consideration?
I suppose, but that would engender hundreds of thousands more dollars in litigation. I would suggest, if I were the court, let the parties walk away and pay their own fees.
Also, that goes to reasonableness.
On
of
appeal, at
fees.
least.
That goes to reasonableness of fees, which the trial court decides. We decide the equities, correct?
Correct. So what I'm saying is, if I'm deciding the equities and I'm sitting where you all are, I would let the parties pay their own appellate fees. Be done with it. And they don't have to litigate about this anymore. It's over. That would be helpful.
Thank you.
Your Honors, thanks so much for your time.
We'll be in recess.